finance meeting, and it's a publicly advertised meeting. We certainly make the opportunity available for members of the public to comment on any topical matters. Anyone wishing to address the board? I see nothing. We'll move along to item 3, the topics of discussion today. First one is the special reports. Mr. Polinsky, you're on.
Oh boy. All right. Thank you, Commissioners, for this time. So the reason I'm here, kind of a long tail to it. Back in August of 2018, Rebecca Finke and I received a task for to provide the commissioners twice a month with updates on the specialty courts. And so I've been doing that. And there wasn't a lot of detail to it, it was just send some updates. So I've easily cobbled together some information and send it to you, but I've never understood if it was meaningful to the commissioners or not. So today, my presence here today is really born out of some conversations Stacy and I had in regards to trying to develop that information, and we thought it would be helpful if I kind of just provided some background. Certainly OIC has been in your forefront lately, but we have a couple other courts, and I thought it would be worthwhile to spend some time to talk about this course, what we do, why we do it, and what some of the results are. And hopefully the goal of today is to give you some better information, and we can have a conversation about what it is that you would like me to tell you on a recurring basis about the problem-solving course. So a little bit of history. These problem-solving courts have been around for 30 years. We celebrated that last year. They were started in 1989 in Florida. That, if you remember, back in the 80s was cocaine season, and we were fighting, like now we're fighting a heroin epidemic. Back in the 90s, 80s and 90s, it was crack cocaine. So the judge created this felony drug court based on those principles. And the bottom one is kind of the most important one that follows through to what we do today. The court provides or brokers drug treatment and other services that help participants achieve sobriety and stability in their lives. And that's expanded. We know there's a problem. We know there's a serious mental health problem in the nation. We know there's a serious substance use problem in the nation. We know that a lot of inmates suffer with substance use disorder, 65% of U.S. inmates. We also know that 10%, on any given day, 10% of the Cumberland County prison population has a serious mental illness. And we spend a lot of money annually on incarceration. So if we can find a better way to do that, it's worth our time. So in the last 30 years, we found that treatment courts are the single most successful intervention for helping people with a substance use disorder who are involved in the criminal justice system. There are over 4,000 drug courts nationally, and there are international drug courts as well based on the model. 1.5 million are served, and annually 150,000 participants are served. 698 DUI courts, and there's 407 veterans treatment courts, and there's a smattering of other courts. In Pennsylvania, you can see we have a lot of courts. Almost not every county has a problem-solving court in it, but most do. And most prevalent are the adult drug courts, and you can see that there are a lot of other courts. Philadelphia has a whole variety of courts to address all the kinds of problems they have. They have a prostitution court and they have a human trafficking court. And so this model works well across a variety of issues. So treatment court, we've been around since November 2006. We were considered a hybrid DUI court, and that's because we have two populations in our program. We have a low risk, low need population, and that's generally the DUIs, but they have a high risk of reoffending with the DUI. And those are usually the third or fourth or subsequent offense participants. And then the other population is the high risk, high need population. So when we talk high risk and low risk, that's criminogenic need. Are they likely to commit new criminal offenses? Need talks about their societal needs. Do they have a job? Do they a home, stay home environment? Do they have the things that get them through every day? And in both of those, we're looking at individuals who have a significant history of substance use disorder and crimes related to that. So the DUI population, they have a history of a lot of DUIs. The other population, a lot of history with other crimes. It can be burglaries, retail theft. It doesn't necessarily have to be a specific drug crime. And we consider treatment court to be a court of last resort. So in order to get into treatment court, they're facing a long county sentence or a state sentence. And we use a post-plea pre-sentence model. So in order to enter treatment court, they have to plead guilty to the charges that they have, but they're not sentenced. The only time they would be, and we use the carrot and stick. So the stick is if they, as a condition of entering the program, and they enter that plea, they waive their right to withdraw their guilty plea. Ordinarily, under a guilty plea, you have the right to withdraw it and go to a jury trial. Enter the program, you waive that right. If you fail out of the program, you get sentenced on those charges. And it's generally right away. So we'll have a hearing to revoke them out of the program, and then they're immediately sentenced. The carrot is, if they successfully complete the program, they'll never be sentenced on these charges. And to make that even bigger carrot, they are eligible to get those charges expunged if they have paid all fines and costs and restitution associated with those charges. And I'll talk a little bit about how that's worked out for folks. So it's a 5-phase program. Pardon me. 4 active phases, and then a 5th phase that kind of, once they've completed the majority of the program, the 5th phase just gets them to graduation. We meet weekly on Thursdays. It's a minimum of 15 months, but generally runs more to the 18 to 22-month range. And really our primary goal is to reduce the recidivism in these populations by engaging them in long-term recovery.
May I ask a question?
Certainly.
And I'm sorry if I'm jumping ahead.
No, very good.
So if a participant is in this program and they successfully complete this program, and are never sentenced on those charges,
Right.
do they have to reveal that they went through treatment court to a potential employer?
No, because it's a conviction.
Okay.
So it's kind of the language on the application.
Okay.
Most applications say, have you ever been convicted of this? And they can honestly say, no, they have not been convicted.
Okay.
Right.
So is it fair to say then that this is helpful?
Oh, absolutely.
It seems to me it would be helpful that you would not have to say I was convicted of something.
It is, but
Okay.
the thing to remember though, a lot of the high risk, high need people a lot of them already have a background that is
Okay.
prohibitive from good employment.
Okay.
So,
The question is helpful to me. So, I mean, if I'm in a situation, say at a nursing home, where I have access to drugs might be part of the job, wouldn't I would not have to reveal it in a circumstance there where it would be, for us, a high risk as an employer?
if they're not expunged, it will still be on their
On the record.
It will still be visible. It'll still be in UJS. It'll still be visible. It wouldn't be
So we're not putting it in the line as an
right,
employer, we're not putting it in the line.
different employers have different levels of what they consider a criminal record. Certainly for a lot of the folks who come through our program, they're really looking at more warehouse jobs, things like that, where it would not be a barrier to them getting employment.
Okay. Thank you. I appreciate that. Thank you.
And so we have a fairly, we can't do it, we don't do this in isolation. So we have a robust team. And those are all what we consider core team members for the program. So the law enforcement piece, we're in a bit of a struggle because the sheriff's office seems to be bleeding deputies like nobody's business. So we understand they have a shortage, but they promised us Deputy Dempsey starting in March. And we're accredited by the Pennsylvania Supreme Court. We're actually in our second accreditation period. They're each 3 years long. And the significance of that is it says that we adhere to the 10 key components of drug courts. Problem-solving courts are probably the most evidence-based, most studied. There's more data available on how this works than probably any other program. They're very structured. Drug courts have the 10 key components. Mental health courts have a similar 10 elements of mental health courts. Opioid courts, there's a set of elements on how to run a successful opioid intervention court.
So there should be an abundance of things that are measurable.
Oh, absolutely.
Okay.
Absolutely. So, and I've just listed the 10 key components there, and I just wanted to point out a couple that are significant. We provide access to the continuum of alcohol, drug, and other related rehabilitation services. We're fortunate we have a pretty robust amount of treatment providers in this area. We can get treatment to our participants in a timely manner.
Is there any consideration given to how many times they may have entered into treatment?
Not really. That's certainly, they talk when they have their drug and alcohol evaluation as part of the application process.
Mm-hmm.
That comes out and that's talked about, but really, the thing about the concept of treatment is they could go through 10 times and they could probably write the book on it, but maybe the 11th time is the time they're really ready for it. And they may have, there's different circumstances why they may have gone through treatment and they weren't engaged in it, but maybe there's a lot of evidence to suggest that forcing people to go to treatment works well. And that's kind of one of the principles, what works in drug courts, and that's why it's part of this model.
So I guess the question is the entry into this, how competitive is it? Are you bumping someone else whose prospects or success would not fit? That's not.
No, we don't. The danger with evaluating people on suitability is that would happen. You would bump you if you made a subjective suitability piece in the application. You would create that.
So in other words, everyone who applies gets in.
No, not everybody who applies. In all our specialty courts, the district attorney has the first right of refusal on all cases. We wouldn't be able to have problem-solving courts without the district.
So if it's a competitive nature, there has to be some determination of suitability.
No, it's not competitive in that term. So to enter a treatment court, the application process is district attorney reviews first. If there are no legal ineligibility reasons, like felony crimes of violence, or a drug dealer, there's a weapon involved, something like that, they're legally eligible. They go to the next step, which is they have they meet with our probation officer for a risk need assessment, and we also do a ACEs. We conduct the ACEs, which is Adverse Childhood Experiences Survey, to determine trauma. Each stage is go, no go. So everybody gets a go, no go. They come to observe court, see it's because this is unlike any other court they've ever been to before. Most of the time they go to court and nothing good is happening. So we want them to see what actually happens in the program. The next step is a drug and alcohol evaluation. Most of the time, if there is a level of treatment recommendation, that's good. We've had a few circumstances where individuals had already, and I use the term, treated themselves out of treatment court. We're a treatment court. Treatment court is an integral part of the program. They need to be in treatment. We've had some individuals who, in the time it takes for their case to move along and for us to get an application, that they've already been through all the levels of care that we would have had them engage in, and they're done. So that would be it's not competitive in terms of, this person is more eligible than this person. It's there, we look at each piece along the way and make an objective determination.
So if they pass all the screens, they are in.
Right.
Okay.
And then the last step is we sit down, everybody, at each step, everybody comes to the table, talks about their piece. The last piece is we talk about it as a whole. Is this person the person we want? And sometimes there's factors that, other factors can, substance use and mental health serious illnesses don't often occur in isolation. In reality, all these three courts are co-occurring disorder courts. Often, you know, we've had a lot of circumstances where we didn't know there was a mental health issue until the person got into treatment court and they actually got clean and they stopped self-medicating, and all of a sudden it's like, oh, you know, so one of the treatment barriers for treatment court is, do they have a mental health issue that we are unable to deal with in treatment court? Are they more appropriate for Tom's court, or would they not meet any of those criteria? We can't. So we make the process as objective as possible.
So you could potentially be referring someone to a different court.
Correct. Yeah. Absolutely. All right. So Tom's court has been around for a little over 2 years, and it's been classified as a mental health court. The acronym together, Optimizing Mental Health Solution, is named for Judge Brubaker's father. And our target population there, individuals with crimes relating to a serious mental illness. The difference between mental health, Tom's court, and treatment court is sentencing guidelines are not really a consideration. To a small degree they are. We had a discussion just this morning about an individual who had very low guidelines, and we determined based on where this person was at with their treatment and all the other factors, and that entering her into Tom's court would be more detrimental to her than just letting her case get resolved traditionally. So her guidelines were RS1, so essentially very extremely low guidelines. So she wouldn't really end up appropriate. So those are the things. But we don't look at, like treatment court is, we're looking at, you need to have 12 months or greater for guidelines. We accept a greater range of guidelines. Because the risk, so we're not looking at risk need in Tom's court, we're looking at, do they have a serious mental illness? And is that crime, do they have crimes that can be related to that mental illness? And again, we've gone to a post-plea pre-sentence model, and the same considerations are made as in treatment court. It's a 4-phase program. We meet on Wednesday mornings. It's a minimum of 17 months. And similar to treatment court, our goal is to reduce recidivism in this population by helping them develop skills to effectively manage their mental illness. And we have again, a very robust team of players. We don't do this by ourselves. Everybody plays a very important role in making the work well. And as you know, today marks the 2nd year anniversary of Opioid Intervention Court. It's unique among problem-solving courts. This is a very new model. We were approached a couple of years ago by AOPC to create a program similar to one that was created in Buffalo, New York. From what Judge Brubaker and I are able to tell, there's only a handful of similar courts nationally. Montgomery County has a opioid court that's really part of their drug court. It's like an early phase of their drug court, and participants need to be eligible for their drug court in order to get into their opioid court. Whereas in our court, it's pretty much open to anybody as long as they have an opioid use disorder. So, and that's who we're looking at, our criminal justice involved individuals with an opioid substance use disorder. So we have 2 groups of folks. They're going to be pre-trial with new charges pending. or they already are in the system, they're on probation or parole, and they have committed a technical violation, and they're pending revocation on those charges, or on that sentencing. Unlike the other two courts where the end game is pretty much dismissal of the cases, our end game is disposition of the cases. So if there's pretrial and new charges, we're looking at a dismissal, some sort of traditional resolution, or move them on to one of the other two problem-solving courts. And we have transferred 17 OIC individuals into treatment court and 2 into Tom's court. And in the case of probation or the parole or probation revocation, the end game there is for the revocation to be withdrawn, so they wouldn't get resentenced on that. That would be a very favorable outcome. It's a 3-phase program, and it meets every day, Monday through Friday, every morning at 9 o'clock. A minimum of 5 months, and really our primary goal is what's established is to reduce the opioid deaths in this population. We found that when we were examining when we were approached to start the program when we were developing, we found that 60% of opioid deaths in Cumberland County were people who were criminal justice involved. So certainly if we can reduce that 60%, that's a significant change. And then we have some other ancillary goals, certainly to expedite cases through the system so they don't languish. And the big one is that opioid substance use disorder offenders tend to be high risk, high need. Certainly they're ripe for reoffending, and so if we can reduce recidivism, that's what we need as well. And again, another very robust team. This one is structured a little bit different. Probably the 3 people on the bottom play a huge role in the success of our participants. We have the certified recovery specialist from Rays, Chris Nye, Kristen Page, and Josh Wolf, who is the Vivitrol program coordinator out at the prison. So what will happen is we get most of our participants from the jail, and if they are engaging in the Vivitrol program, then Chris or Josh follows them through from release through into OIC and follows them as they go through as part of the Vivitrol program. So one of Judge Maslin's favorite sayings is, "Not everything that counts can be counted. Not everything that can be counted counts." So this morning, what Judge Brubaker, the starfish story that Judge Brubaker talked about, is one of those. Not everything that counts can be counted, and that's the people side. We look at what these programs do for individuals. They make significant changes in their lives. They get children back. They get stable housing. They get employment. They're productive members of society. They don't recidivate. Everybody's got a great. And what we found in OIC is
all of those things are countable.
All those things are countable, sometimes not easily, but they are countable. And so, but we do have a lot of things we do count. And so those are the numbers for treatment court. In the time that treatment court has been around, we've entered 245 people. Our graduation rate is 50%, 53%. 36% of those don't make it through. One of the changes we're getting ready to implement in June in treatment court is splitting the program into 2 tracks. So right now, both our high risk, high need, and low risk, low need people get the same amount of programming. And the best practice is that low risk, low need people need a lower amount of supervision and a lower amount of programming in order to be successful. Really what they found is that too much supervision and too much programming can have a detrimental effect on their supervision. So we're going to split into a low risk, low need track and a high risk, high need track, and with the goal of increasing the number of graduates and hopefully changing the amount of recidivism.
Call it a night.
For what it's worth, that quote, I'm very familiar with it, of course, from business school, but I can tell you, it is not intended to say we don't have to count. The premise, the context of the quote is that you have to count a lot more things to gain perspective.
I understand.
Paul, how did you get the prison bed days saved by graduates?
So, I take it, and this is a subject that is of great interest to all the coordinators because it's a sometimes hard number to come by. So what I take is the bottom of the standard range of the charges that they entered treatment program, knowing that were they to get sentenced, that probably would not happen, and that probably there would be some concurrent time run, but without having the ability to predict what could happen, that's kind of my standard calculation. So if they have, 12, if they have a DUI that's 12 to 18, and they have, and they were also brought into court on a driving under suspension that has 90 days, well, then that's 15 months, and that's going to be my calculation.
Okay.
Yeah, they're, oh gosh, I think it was Travis from our warden. I seem to think, what is the average period of time that they spend in the county? I think it was like 47 days.
Right.
And what I did, I was using a set of numbers that are not quite as current as this, but I took the number of graduates into the number of days, and it's coming out to about a year and a half.
Well, the thing to remember is that these are all, in order for them to be in treatment court, they're facing the lines. I'm pretty sure that, and again, these are all the high risk people. So these people have the highest likelihood of reoffending, and they've been in the system a long time. So probably, that average is based on, you have a lot of first-time people who, are in there they may get sentenced, they're in jail for a short period of time. You have some people that are sitting in jail for a year or more, and so it average. So average is a difficult one, and I recognize that, these numbers are probably a best case scenario.
But if I can jump in there, and these are people that, if we're keeping them in the county, we would be sentencing for them to 11.5 to 23 months, or a year less a day, 2 years less a day.
Right.
So that's what all those people are in that population. They'd either be going to state prison, or they'd be going to max county sentence. So they wouldn't be getting 30-day sentences.
Okay.
Would any of them be paroled? Would be eligible for parole?
Well, after they serve their year, or year less a day, or whatever. But
Okay. Now, it states here that prison bed days cost savings by graduates about $5 million. And that's over the life of the court, which I guess is 14 years. Okay, do we know what the cost has been over those 14 years?
Well, the cost I use currently to calculate, and that's, again, so I use the, $67.23 right now. I'm sure that when we started in 2006, 2007, it probably wasn't that much. Have not gone back and amortized that against all the.
No. But what my question was, what was the cost of having the treatment court during those 16 years? Forget about the proposed savings here. What did it cost to have the treatment court in operation here in Cumberland County? If that makes sense as a question.
It does, and I don't have a specific
Okay.
answer for you, but I do have later on, I think I can address that with you.
All right, thank you.
So, I'm hearing both commissioners asking data-driven questions, which I think are very important.
Right.
Okay? And before I ask this, before I let you know this next piece, I am going to say this because I have now been to opioid court twice. Or I've watched a woman with the same baby, all right, who's in that treatment court, who I mean, no one can see into the future, but it would be my gut that had she not been able to be involved in an opioid treatment court, we would have a child without a mother. How much does that cost? We would possibly have a children and youth problem. How much does that cost? And I know those are very, very touchy-feely things, okay? And I'm sure that there's a way to measure those in the long term, but I don't know how you measure that day by day. But as an aside, knowing Dana best and knowing what she knows about finance, have the two of you gotten together on this to come up with really good numbers?
So the answer is yes,
Okay.
and the answer is no. Because it's multifaceted, and we
Okay.
have many, many different treatment courts. And the way that we have designed our financials is more departmental than court-driven.
Okay.
Okay, so our financials aren't designed to pull easy measures out by program. For example, when you go to the list of people that are involved in treatment court, they span 10 different departments. And so
Yes.
the only time that they come into one department is if there is a grant-driven mechanism. So we don't
Okay.
have an easy way to say treatment court costs this much
So,
without a big evaluation by an external.
Okay.
so let me go back. Clean this up. So on that team right there, the only person who is whose salary is paid for them to be on treatment court is Angie Shire Williams.
Okay. Okay.
So everybody else is out of their department.
Okay.
But
I'm
their
gonna-
hiring was justified by the fact that they are.
No, it wasn't. So, like, drug and alcohol case managers, their positions would be fully justified with the amount of work they do without being in treatment court.
I'm saying that's not how it was presented to us during the last two hiring decisions.
Well, we were talking about opioid recovery.
Okay, I think I'm thinking about the same thing, but I maybe.
Like, we've not had these discussions, I've not been privy to any discussions with the commissioners regarding salaries and treatment court or conflict, only opioid recovery. Great.
So I'm just gonna say this because I'm getting this vibe off of my two fellow commissioners, and I think this is really important that the vibe is recognized, okay?
Right.
I'm a far more touchy-feely person than these two are, all right? I like these two boards, or these three boards. I think they're critical. I don't know, I haven't asked the two gentlemen where they're at, but I know they're both data-driven, and if we like them and we want them, we should do the best that we can to satisfy their need for information. And I think that Commissioner DiFilippo asks a good question when he says, if we hadn't put these people, if we had put these people in prison, what would it cost? I think that's a number we could come up with.
Yeah.
Okay?
And so we do that, and we do have those numbers historically in our budget.
Okay.
However, the question always comes up is, how are you tracking that, and is it a reasonable number? And that's where we start getting,
In the weeds.
how much does the program court cost versus how much we're saving? And because of how we track the courts,
There's no
There's
way
a
to
lot of
know
estimation.
what, there's
You're
no
not
way
gonna
to
get a
know
precise
what
number, but you can get an estimation.
we would have sentenced them to. This is a
Right.
whole, these are people who are never sentenced, and there's no way, and there's 7 judges, and there's no way to know what I would have sentenced them to, or what Judge Rito, or Judge Mack,
Okay.
that we would have sentenced them to. You
Okay.
can presume it's within the sentencing guidelines, because 80 to 85% of our sentences probably are, there is a number that AOPC keeps on how many are, but we're supposed to sentence in the guidelines without a reason. So that's why Paul chooses the low end of the guidelines, is because that's a reasonable place to start,
Okay.
because judges are said to start with that sentence in the guidelines, so.
Okay.
and we should.
Does that help you two at all?
Let me just make a
Okay.
comment or two on that too. I don't dislike the program, but I have to do our due diligence on this, okay? Because we have a fixed number of dollars that are involved, so we have to do our due diligence. I've been to the court too. I've seen the faces of some of these people. My concern also has to be with the people that are visible to us, and we know there's limited dollars. If we start making budget decisions based on the anecdotal information given to us, then we're gonna be budgeting for the people who are the most persuasive, not the people who we can help the most with limited dollars. So that's why the data-driven part is important to me. Now, having said that, I agree, not everything can be counted, but there are lots of things that can be counted, and we've had some of this discussion before. My question fundamentally for each one of these is, how does it compare to a situation where it wouldn't exist? So you've got something to compare against. All right, so you've got the existence of no courts is one possibility. How about the other similar programs? You pointed to a number of these programs in several of these areas that exist elsewhere. So I want to know how we stack up against them. And some of these, let me finish my thoughts here. Is the opioid court is a pilot program. A pilot program by its definition means we are trying to learn something that is unknown. So we have to be figuring out what works and more importantly, what doesn't work, because that's how best practices are identified. So to do that, we have to be measuring and monitoring things to find out what's working, what's not working. The operational measures is something I've talked about numerous times here. There's other programs, then you can certainly see how we stack up against them in terms of what's being done, how well it's being done, how efficiently, how many man hours are taking to get it done. So we're certainly going to be interested in the efficiency measures because we have to be.
Sure. And that's why I'm here and we're having this conversation.
Yes,
Paul-
which is excellent.
Paul, my question, please understand, and you probably do, it's not personal against you, it's not, all the people listed there do a fantastic job. And today, the OIC court celebration, hearing a couple of those people speak, it was really enlightening. So, you know, not that I don't support what's going on, but as Gary said, we need to know, you know, how much does it cost? What are the results? And not the exact numbers, but at least something, you know, when someone asks us, you know, I'll give you, and again, I don't mean to sound like a jackass or anything. 16 years, 14 years, we've had 131 graduates out of treatment court. And the OIC, in just 2 years, we've had 58. Now, I may not be comparing apples with apples, but just off the cuff, it seems to me that OIC is far more successful than the other two courts.
And actually, you're comparing apples to oranges.
Okay, and that's what I need to know.
There's a whole different set of outcomes. Certainly, OIC is not intended to generate the same kind of outcome as the Thomas Gordon Mental Health. We're looking at different populations of people, and the expectation for how successful people will be in OIC is different than the other two courts.
Well, that's why your enunciation of specific goals is important, because that's how you determine whether you succeeded or not. So, and what numbers to use to make that determination.
So, if I may, so in your mind, when does OIC stop becoming a pilot and become a program?
I would say the onus is on you folks to prove to us that it's worth continuing. And that means meeting the informational needs that we have, that it's the best investment we could make as opposed to investing in some other area of human services. So, you know, we've never had that discussion as a board as to at what point it stops being a pilot program, but I will say this. Some people around this place, not you, need to learn that pilot program is not a backdoor way into the budget that absolves the organization of having to justify anything.
Correct.
So, and that there is just this perception, if we call it a pilot program, it gets in the budget, and after a while, that moniker just falls by the wayside. It really doesn't. I mean, everything is subject to approval on an annual basis. And what I'm trying to do, and have been trying to do here, is to get us on a more systematic basis, so that when the inevitable time comes that we look at our budget and we say, we're gonna have to make some reductions somewhere, because those things do happen. I've been here long enough to see it at least twice, that we're not cutting the wrong thing. And we give ourselves options in terms of, we're not backed into the corner for another 33% tax increases was what's suggested. And that we can make a smarter decision so that we're supporting the things that get the biggest bang for the buck.
I think one of the good things you could do, and I was not here when these things happened, but it is my understanding that the opioid intervention court was the solution to not opening a new wing in the prison.
That was one of the considerations.
Okay. And I think that even getting Travis Shank involved in this discussion on what is the effect in his world and on his life, because you know if we are treating these things as silos, we're not getting anywhere. And Dana, knowing that this is such a young program, I'm not convinced that the data is there yet to really be super measurable.
The problem is there's nothing to measure it against. So we
Okay.
started to follow Buffalo. Well, Paul and I were in Washington DC for 4 days with the Buffalo court. It is nothing like ours. Like, they don't even have sanctions. I don't even know how it runs, to be honest. We still, after all that time, don't know how it runs. There's one in Tennessee that is for pregnant females. That is their population, on parole, pregnant females on parole. I don't even know how they have a
So then how do you know if it works?
Correct. Well,
Right.
yeah.
I have 128 people that I think are proving it works, but that's what I have, and that's the problem.
Right, go ahead, Dan.
And our difficulty on the other side of it is we never have tracked historically how much a standard person like that costs going through the system, because the costs are done by department, not by case, right? So as an offender, we don't have a good data roll on how much that case costs the county and the state, because there's a state piece to it.
Mhm.
And
Especially
without
a
that,
heroin
it's
addicted
very.
offender, because a heroin addicted offender costs more than a non-heroin addicted offender, going through our
And how-
social services.
And how much
Correct.
that person costs to go through the whole way through the system in a normal case is not tracked. And that's our baseline, I don't wanna say failure, but that's what we should be
Right.
tracking against, but we don't have it.
When I even think about tracking this, I mean, there was the Carlisle Borough Police were there this morning. I'd love to know what the effect of this court is on what they have to do. I'd like to know what the effect is on law enforcement throughout Cumberland County. Mr. Hicks, yeah.
Yeah, thanks. Just a couple comments. I'm with Carlisle Borough Council, but I teach public policy, so I'm here more interested in public policy than with the borough. But looking at some of the things we're measuring, I mean, if you look at it from a social cost perspective, there's a lot of things that we could include that may not necessarily be directly affected to your budget, but for instance, the tax revenues that these folks are now contributing as a result. So these sorts of things aren't popping up here. And I think there's probably, if you give me an hour, I could probably think of 6 items that are supportable. We don't have the luxury of maybe doing the gold standard of a randomized control trial, although I think that would be kind of interesting.
Okay.
But short of that, I mean, I think we could come up with some other measurable things that are parameterized based on the information we have that says, here's the social benefits. That you know, here are the assumptions we made, and I think we can get it. You could come up with a pretty compelling bound of what the overall benefits would be. They go a little bit maybe further than the rest. That's my thought. And I have a little bit of time, but I think this is a really interesting from a public policy perspective.
Could this be a
Program.
class project perhaps?
Keep talking. I do actually teach a class of public policy, and I would, that might be something that would be interesting. It is undergraduate, so caveat. But I would
Yes,
be
Dave.
very interested in something like this.
Yeah,
I'm interested in helping if he's.
awesome.
Great. You know how to find me?
Yes, we gotta make sure you two get connected.
Paul is probably a very important player.
Well, yes, oh, absolutely. Well, I don't mean to
More
lecture
important
at
than
all.
No, and these discussions, my mind, okay, so who do I need to talk to? So anyhow, so at the risk of
Okay.
like stirring this pot any further, we'll go, but I do have slides prepared, so we'll go through them. So for treatment court, what we found is that carrot works pretty well. So we've had 69% of our graduates have had all or some of their treatment court dockets expunged. So that worked pretty well for them. A fairly low rate of in-program reoffending, and compared to traditional outcomes, 19% of post-program reoffending is pretty good. And then within the 2 years is kind of the standard that we use across the board
Okay.
for all the problem solving. So Tom's Court, it's having only been around for 2 years, there's not as robust amount of data to compare to treatment court. Certainly we haven't entered as many people, we haven't graduated as many people, and we haven't had as much reoffending.
And I will speak to the termination. When we started Tom's Court just with probation violators, and we were trying to get a handle on things. So, for instance, we entered somebody with a traumatic brain injury, and we quickly learned that that's not somebody who can receive effective treatment, so they were terminated. So a lot of that number will, I think the percentage will go down as we go on, because we're figuring things out, like, okay, this person isn't a good fit for our mental health court, and now we know that going forward. So like traumatic brain injury, like I said, doesn't respond to traditional mental health treatment.
So they are or not in that.
They're in that, and
They're all
terminated,
included.
so, yeah, so.
I don't have to tell you this because I know you're delving into it, but that's what asterisks were.
We'll get there, sir. We'll get there. We're gonna get there.
All right.
We have a lot of aspects.
So, great. So these are our current numbers for OIC.
And we've entered so many because we can handle a whole lot more, because they're,
They move through faster.
yes, it's a quicker program. We're seeing them every day, so while that's more work in some ways, it's also, we respond quickly to problems, and problems have a less time to get out of hand. It's a very good.
So,
I do believe to some degree that the OIC has reduced prison population.
I believe.
well, and it has, because the majority of people that we admit come from the jail.
Right.
And they would otherwise be there much
We have
longer.
a very difficult time getting people in from the community. That's what Buffalo is, New York just did their bail reform, and so all misdemeanor, there's no cash bail for all misdemeanors, all of a sudden the Buffalo.
Isn't that the policy they're looking to reverse now?
That's-
It is, but what's happened is the Buffalo opioid court now all of a sudden can't get people into their program because they're all in the community. So that's
But
what
we
it is.
have 16 people in jail right now being screened to come into OIC, so if they enter, and some of them are entering this week, they're coming out of the jail, 16 of them.
But I'm gonna ask in a second, Paul, I'm sorry, I keep interrupting
Listen.
your presentation. I just am so interested in this.
I'm here,
So this morning, I was speaking with a man, and I know that this is not what we're here for, but he said that he has a shot of Vivitrol, was administered a shot of Vivitrol, and it lasts a year.
No.
Did I? Okay, because I thought maybe I
He
misunderstood.
said he was on it for a year, and now he's no longer on it. is what he was
Excellent.
telling me.
Okay, I was like, wow,
It's a
that's
month.
like.
it's a month.
Okay, thank you.
So we're, in all of our programs, we're medication assisted treatment friendly. So we encourage people to, and certainly because a lot of our OIC participants are coming from the jail, they have the opportunity to engage in the Vivitrol program and come out of the jail, and that's a win. So the advantage to MAT is that it gets them stable enough to where treatment starts working for them. The problem is what we found is the abstinence only model has some problems. Some people can do it. Some people can do abstinence only and they're fine. They work through it. A lot of people can't. So if you get them on MAT, it'll stabilize them long enough where the treatment that they're in. MAT is not meant to be standalone. It's meant to be partnered with other forms of treatment. So if we can get them on MAT, get them stable, so they're not fighting urges all the time, they're not fighting that piece of the addiction, then the treatment starts becoming effective. So that's the value of Vivitrol. It's a month-long shot. You just get their shot. They don't have to worry. They're not dosing every day, and so it works pretty well. And it's intended to be used a year, or at least a year.
Well, and that man now sees his daughter,
Right.
and he was not. So, I mean, there it is. I mean,
Yeah.
I don't, that's pretty
Yeah.
damn successful.
Yeah.
Yeah.
So going back to our primary goal of preventing overdose deaths in this population, so out of 128 people, we've had 2 overdoses. And your asterisk on that is one of those deaths was a person that we had been terminated from the program because she came in, she was hot, she tried to substitute her urine, and so that was counted as a new reoffending. We terminated her from the program. She did her jail time, she moved back to Dauphin County, and she subsequently overdosed and died in opioids. And then the other one, was we did have one in-program opioid overdose death.
And we should have 25 asterisks on the number 48, but I can't keep track of all of them. Because they're the ones that I was speaking at. One of the girls that spoke today was one of those people that were unsuccessfully terminated and are doing fabulously now.
So that was the first time I saw her since she was in OIC, and it was a completely different person.
Yes?
All right, so.
Hang on.
Okay.
Dr. Hickson.
So since this was the key outcome, 2 out of 128, that's like less than 2%. What was do you have any historic rates for that same size? Would 5% or 10% or?
Well, again, the problem is the unique program that kind of is, there's not a lot to compare to.
Right.
We know that in 2017, we had a high of 86 overdose deaths in the county. And that
41 last year.
41 last year, yeah. So, and again, I'm not here to tell you that OIC is the end all be all and we have cured the opioid crisis in Cumberland County. We're one of many partners that works, and we recognize that there's a lot of agencies and individuals doing fabulous work to make that happen, and this all works together. But for the population that we are targeting, the 60% that died who are criminal justice involved, we made a significant difference.
Thank you.
So, this doesn't answer your question exactly, but the NADCP, National Association of Drug Court Professionals, is kind of our national association that oversees all the problem-solving courts, and so what they're saying is that treatment courts produce benefits of up to $6,206 per participant, or a return of investment of $27 for every $1 spent.
They obviously have a methodology for.
They, again, it's difficult, they're looking at, reoffending, how much, law enforcement contact, did people get their kids back, there's a lot of, if calculating the return on investment was easy, I'd be here telling you.
Yeah,
what
but
our
our point is that there
return
is an existing framework by which someone is doing it, so
Sure.
that provides an ample opportunity for comparative data
Sure.
for us to measure against.
Yep.
Is it possible, so if obviously the National Association did those metrics. Do we have a contact with them to say, how did you do this? How did you start this? Do you have any recommendations for us on how to start collecting our data and measuring it?
I'm pretty sure there is.
Okay, that might be another really good idea about how we figure this piece out. Okay.
So, is there any other questions on return on investment?
If I do, I'll email it to you.
I'm sure. I can't. So we, AOP's, Research and Statistics Office does some they pull some data and they post it on their site. And there's like 4, 5, 6 data elements that and they're working on expanding that. So there's some county-specific and state-specific data available on the AOPC Research and Statistics website. So what Stacy and I had talked about is and again, one of the purposes for me being here is to be able to provide a recurring set of data to you that is meaningful. So that's in a format that makes sense. So if you have time and you can look at that and see, is that those things. So they measure how long people have been in the programs, how if they were employed at the end when they graduated, successful, unsuccessful, and there's a few other data points. So that's certainly something to consider if that's something. Again, I'm here to advocate for these programs, and I fully understand all of the considerations that you need to make, and I want to give you the best information possible for you to make those decisions. So
I think one of the things that's forgotten sometimes about performance measures is that it really is an iterative process. And the more experience you have, the more you know what you're missing, what you can add, whether it's addable and all that. So it's constant refinement. So we'll touch on a number of these things again, I'm sure.
And the other issue is making them in the recent history enough that they're meaningful.
Right.
Because a lot of our data sources are 2 years old.
Right.
And that becomes an issue of.
Well, we want trend information too. So
Correct.
that historic data is helpful.
But when you're in a program that's only 2 years old,
Right.
there's no historical data yet
Right.
built. And that's some of our difficulty is finding a way to do current measures and long-term measures, so that we make sure that we're driving the program in the right way currently and not falling with old information that could be outdated. So it's a combination of both. And that's what's hard to navigate in the criminal justice world.
Good.
Okay. Good.
Thank you, Paul.
Good.
Excellent.
Thank you, Judge.
Thank you.
And Mr. Hicks, thank you for being here.
Okay, I think we have another
Yep.
item. Nobody has any further questions regarding the process?
Paul, if you just stay where you're at for this, that would be great.
Commissioner
Judge
Caution wants-
Brubaker and Dr. Hicks, that would be great if you just hang out and listen, because I'm so glad we had this conversation today. Because yesterday I got a phone call from Mike Pykosh, and Mike Pykosh is the chair of the Cumberland County Bar, and I wrote foundation, but I have a feeling.
No, it's foundation.
Thank you, okay, all right. And he discussed with me how important the opioid court is, and how excellent it is, and how successful it is in the Commonwealth. And then he mentioned to me that the Attorney General, the Commonwealth of Pennsylvania received a very large settlement. And he called them opioid bakers, but they weren't opioid bakers. They were pharmaceutical companies. And he then expressed to me, and I put this in your packets. So there's a group of attorneys general, Shapiro, Stein, Slattery, Paxton. They have a $48 billion deal with Cardinal Health, McKesson, AmerisourceBergen, Johnson & Johnson, and Teva. And of course, this money will not be paid in one giant lump sum to the Commonwealth of Pennsylvania, but it's coming in pieces, and it's being split with these other states. And he said to me that Judge Brubaker and Representative Rothman had gotten together, and there's a copy of Representative Rothman's letter here asking for a piece of those dollars to come in to help fund our opioid court. And I think as a group, we should really get behind that. And I think it could start with the 3 commissioners writing a letter to Wolf and to Shapiro. Akin, and maybe with a little more fact to it, right? Maybe a little more data driven than what Representative Rothman wrote. I think that's a start with it. Mr. Pykosh had suggested that we ask for $3.5 million, and I don't have a problem shooting that high, and then we can see what happens.
Was there any,
Go ahead.
But it's my understanding that that money was going to be dispersed through grants through PCCD.
Well, and that's another piece that I can't figure out. And I have added more to these packets, because there's definitely a grant program. Mr. Pykosh expressed to me that these letters, even though Representative Rothman is on the Appropriations Committee, are just kind of sitting somewhere. No one has acted on them, no one has said a word. So if the other two commissioners are agreeable, I think we could start with writing a letter saying we'd like to have a piece of this. I think it would be excellent if we could get Warden Schenk on board with writing some kind of a supportive letter in that way. I think Judge Brubaker, I don't know what your rules of ethics say, but if that's something you can do.
Usually I can't ask for money, so,
Okay.
and that's why I refrain from doing it.
Then we've got to keep you out of that. Can Paul do that?
Sure.
Okay. So I think it's something that we should act on. I asked Mike yesterday, I said, has Representative Delozier written a letter? And he's like, no, but, she could do that too. I'm sure, Representative Klein, I think we could approach her and ask her to do it.
Well, and Jean, just so you have
Yes.
some information, I did speak to the governor's opioid command task force about a year ago. So I think that's how some of that came to be with Greg Rathman and
Okay.
so they are definitely aware. I went there in person and spoke to all those heads of all those agencies, so
Okay.
they're definitely aware at their invitation
Okay.
about OICs.
I think we have a really good opportunity to very powerfully lobby for a piece of this money.
Are you saying this would be a specific, like it would go specifically for opioid court?
Well, their money is targeted to opioids, so it's limited to.
So
Maybe drug
it's the
treatment
only-
court it could help with too, but it definitely has that opioid
As
element.
opposed,
Yes.
yeah, as opposed to the county just saying we want a piece of this to pay for our prison costs, our
Right.
blah, blah, blah.
No, it is opioid related.
So it would be
Yeah.
essentially earmarked for the opioid court.
And then, there was another piece here. It's about this grant program. It's the Community Drug Abuse Prevention Grant Program. And so my next question is, have we even looked at this? Because the grant period begins July 1, 2019. The grant program is available for the purpose of bringing an age-appropriate, innovative, and fact-based educational program to students, parents, and community members. This message is limited to the dangers. So I know that's not funding for the opioid court, but I wonder, have we gotten involved in this? There's some things going on, I think, well, I know, at the Commonwealth, based upon what I've read, that we should be jumping on this.
It would be helpful to me to have a more complete picture, because we're already part of some case that I'm not that familiar with, frankly, because the feds wanted to do one, and Shapiro wanted to do his own, and there was some controversy there. But,
Is it this one?
well, I'm a little surprised, I'm not familiar with this settlement, because these
Okay.
companies are all drug distributors, they're not pharma companies, other than Teva, which is a generic maker, I think they're in Israel. But, the real culprit apparently is Purdue Pharma, once you made it.
See, Representative
Is that a
Rothman
different
says,
case, or?
Pennsylvania received $53 million of the $1 billion in new funding designated to support access to treatment for individuals who
Yeah.
struggle with opioid abuse.
It would be helpful to know how many pots of money there are, how many cases there are, court cases there are that we're participating in.
Gene,
Yeah.
Jack Carroll might know something about the
Okay.
Community Drug Abuse Prevention Grant Program.
Okay,
And Jen Hipp might know something about your lawsuits.
got it.
She
Thank
might-
you.
Or Keith.
I know Keith was
Yeah,
involved
right.
in the discussions with us early
Yeah.
on, and I kind of keep track of that sense, so.
Well, and I always like to think about the shortest distance between 2 points. And I wonder if Rothman's office could just answer the question about where he got the $53 million of the $1 billion. I will.
He didn't take my calls.
So,
I would
yes.
support such a request. I mean, what's the worst that can happen?
Well, they'll say no.
Yeah, I just think we need to understand the context of what we're asking.
Yeah, I
so-
don't disagree, and one of the reasons I wanted to bring it at this meeting is that I am so new, and I'm here looking at a group of people that have a lot more information than I do about the way that these things work and what we already have at the county, so. Okay, then I'm gonna investigate what we'll put in a letter to begin
I'll
with.
try to digest the rest of this. too.
Okay, all right. Thank you for your consideration and your time.
Very good. Is that all?
That's it.
Very good.
Thank you.
Okay, very good.